So what is a contract of employment? A contract between an employer and an employee or worker is a legally binding agreement. This could be a contract of employment or a contract of service, so it can be either or. A contract can be agreed verbally or in writing. As a general rule, though, the law in the UK considers a verbal contract to be legally binding as a written contract, and therefore they do uphold in court. However, where you may encounter difficulty with a verbal contract is proving the terms of that contract, for which you'll need to provide evidence to the court should you ever see yourself in an employment tribunal. So looking next at the different types of contracts that we have. So there are various different types of contract, and each will depend on your type of business, your type of industry that you're working. Some work better for certain areas than others. So the main ones that we do come across then are the full-time and part-time contracts. So they'll be for your permanent staff that you have within your business. And most contracts do have that, these permanent full-time and part-time contracts. There's also fixed term contracts. So these can last for a certain length of time, 6 months, a year, for example. They are set up in advance with the employee. They end when a specific task is completed. So that could be a project, for example, that you've got somebody to work on, that you've got them in to do. End when a specific event takes place. So it could be that you have, they're doing a big lunch, a meal, for example, a dance maybe. And, once that is over, then that contract comes to an end. Fixed term employees, though, must receive the same treatment as full-time permanent staff. Okay, so that's really important to remember. Just because they're on a fixed term contract doesn't mean that we treat them any less, any detriment to them in any way than we would a full-time member of staff. We also have contracts for agency staff. So as an employer, you can hire temporary staff through agencies. So this means you pay the agency, including the national insurance contributions, any statutory sick pay, for example. It's the agency's responsibility then to make sure that their workers do get paid and they have the rights under the working time regulations. It's important to remember that after 12 weeks of continuous employment in the same role, agency workers get the same terms and conditions as permanent employees, including pay, working time, any rest periods between shifts, night work, breaks and annual leave. You must provide the agency, though, with information about the relevant terms and the conditions in your business so they can ensure that the worker gets equal treatment after 12 weeks in the same job. You must also allow the agency workers to use any shared facilities. So, for example, the staff canteen, any staff areas, staff rooms, that sort of thing, and give them information about any job vacancies from the first day they work with you. You're still responsible, though, for their health and their safety whilst they're on your premises. We also have freelancers, consultants and contractor employment contracts as well. So if you hire a freelancer or a contractor or a consultant, it means that they are self-employed or are part of another company, for example. They will often look after their own tax, the national insurance contributions they'll have to pay. They might not be entitled, though, to the same rights as workers, such as the minimum wage. So they will set their own wage per hour, for example. And again, as with the agency staff and the fixed term contract staff, you are responsible for their health and safety whilst they're on your premises, whilst they're at your place of work. And we also have 0-hour contracts. So these have become more and more popular during COVID, for example, when there wasn't the work available for employees. So 0-hour contracts then are known as also casual contracts. 0-hour contracts are usually for a piece of work or an on-call work. So an example could be that you might have somebody, an interpreter would be one that possibly maybe use this contract. So a 0-hour contract, what that means is that they're on call when you need them to work, they're available. You do not have to give them any work because they are on a 0-hour contract. However, the employee, though, doesn't have to agree to do that work. So they don't have to do it when they're asked. They can almost pick and choose the hours if they're available, if they want to work them or not. 0-hour workers, though, importantly, are entitled to statutory annual leave and the national minimum wage in the same as any regular employee. So they will still accrue annual leave when they work for you, and then they will have to request that leave in the normal way, and then it's an average of their earnings. There's quite a long calculation that you use to work out their average annual leave that they've had so far that year, and it's worked out in hours. You can't also stop a 0-hour contract or 0-hour employee working or getting work elsewhere. The law does say that if they can ignore the clause in a contract, if it does ban them from looking for work or accepting work from another employer. And again, as with the other contracts that we've talked about, you are responsible for the health and safety of the staff when they're on your premises, when they are on a 0-hour contract. So there's lots of different contracts there to suit every need, really, with regards to people coming in and doing the work that you need them to do. So that's just a list of all the different contracts that we have that are available to everybody. So when does the employment contract begin? So an employment contract, as it says on the slide, begins when the employee starts work, even if there is nothing in writing. The contract might begin even earlier, though, if all of the following, as it says on the slides, apply. So if somebody has accepted the job offer verbally or in writing. So it's really important, once you've decided who you want to hire, who you want to take on, you'll need to make them a job offer. Now that job offer can be made verbally, as it says on there, but it's always better to put it in writing. It then just avoids any misunderstandings later on down the line because, you said this to me when I first accepted the job, but it's not in the contract. So it's always good to have that in writing. Within that job offer letter then that you're sending out as part of the contract, it should always include certain things. So, for example, a job title, confirmation you've offered them the job, any conditions, so for example, that the offer depends on suitable references or health check, for example, that then would be known as a conditional offer of employment. So any terms, so for example, their salary, the hours they're going to be working, any benefits, any pension arrangements that we've got with the company, what their holiday entitlement would be, and the location or the place of their work. We'd also add in a start date and any probationary period. So probationary period can be a month, 3 months, 6 months. That's when you're getting to learn about the employee is getting to learn about your business and to understand if that employment relationship is going to work. Also within the offer letter is what they need to do to accept the offer or to decline it. So it's important to remember that sometimes people don't accept our offers of employment, and then we'd expect them to decline in writing that they're not taking it any forward. And also the name of the person or with, and their contact details of who they need to speak to in case they've got any questions regarding the offer letter. Also the contract, so the offer and making sure that if it was unconditional or the person met all the conditions. So it could be that you were looking, to get references from them and then you were satisfied with any references that you've received back. It could be that you're pending a DBS check to make sure that they are safe to work with vulnerable children, for example. So that would be what we'd call the making sure they've met all those conditions of our job offer. And then the employer sets out the terms of the job in a clear and definite way, verbally or in writing. So as previously said, it's always best to put that into writing, so it then just stops any misunderstandings going forward should there be an issue with their contract once they've received it. So what must the employer provide in writing? So anyone that's legally classed as an employee or a worker has the right to a written statement of employment particulars. A written statement then would include the main terms of someone's employment, such as pay and working hours. Those legally classed as workers do not have the right to a written statement if they started the job before the 6th of April 2020. This document, this written statement of employment particulars, is often referred to as the employment contract. But by law, the employment contract is broader than just the written statement. For example, then, employment law is also part of an employee's contract, but usually the law will not be written in the full statement. We're going to come on to that. So within a contract, it's made up of certain things that have to be in there. So these are known as express terms, implied terms, statutory terms, and incorporated terms. So an express term, this is a specific term agreed in writing. For example, the employee's pay and the working hours they'll be working each week. Okay, so that's express, it tells them expressly what they're going to be doing. Implied terms, so these are too obvious to be written. It can still be a good idea to put these in writing, so everyone's clear about their rights and their responsibilities. And then statutory terms, these are part of the employment law. They're the important ones that we need to make sure we've got in there. We have incorporated terms. So these are terms we put into the contract from other sources such as the staff handbook or an agreement affecting many employees. It's important to remember that information in the contract must follow the law. For example, stating that employees paid £4 an hour would be against the law because that is less than the minimum wage. So there's some things the employer does not need to put these types of terms into writing. So the exception is any information that must be in the written terms. For example, if the employer pays an employee a minimum wage, they must display the amount in the written documentation. So you can put in the amount by hour. Some people get paid by the hour and some people are on an annual salary. So as long as there's a figure in there per hour or by annual salary of what that employee is going to get paid, that needs to be written into the contract. There's also terms that are too obvious to be written in a contract. So, they do not have to be written there. So, for example, such as not stealing from your employer. OK, that's an obvious term. We'd hope that people don't go and steal from us whilst they're at work. Even though if they're unwritten, these types of terms are often crucial for an effective working relationship between employer and employee. To prevent any misunderstandings, it's still a good idea for an employer to make the following clear. For example, this could be in written policies, it could be in your employee handbook, so it's always good to have one of those alongside your contract of employment. And the things that we'd expect to see there in that handbook would be things like the standards of behaviour that we'd expect from employees. For example, anyone who's dealing with any customers should be polite, for example, when doing so. And also what happens if they're not met. So, does for example, the employer will report any thefts to the police, for example. So that employee is aware of the situations. We also have a term that we refer to quite often within our contracts, is the custom and practice. And again, these are often unwritten. This type of term, though, could become part of the employment contract when the following apply. So it's generally well known in the business or the industry, usually over a period of time. It's reasonable and it's certain. So if I give you an example of that, an employee could expect a Christmas bonus of £100 this year if their employer has paid annually for the last 10 years to everyone in their team. So to prevent any misunderstandings, it's still a good idea for the employer to put in specific custom and practice terms into writing. For example, that getting a Christmas bonus does depend on the business profit in the latest financial year. So you're putting a caveat onto that written process. So we've done our contracts of employment. We've got them written. We've given them an offer letter. What happens though if we want to change that contract? Because things do happen and changes do happen within our businesses. So as discussed previously, a contract between an employer and an employee or worker is a legally binding agreement. A contract can be agreed verbally or in writing, as we have discussed. If we're going to make any changes to a contract, these must be agreed by both the employer and the employee. In some circumstances, changes must be agreed with a trade union or other employee representatives. Changing a contract then is sometimes called varying a contract. And if we are going to look to change an employee's contract, we need to enter in a period of consultation with that employee and give them 30 days notice of that change of their term or their condition of employment. So some examples of when an employer may consider employment contract changes. So you may look to make sure the contracts are up to date with new laws or regulations. It might be that you want to better reflect someone's job role if this has changed. So for example, if they've had a promotion, you might want to make sure that that's up to date with them. You might want to introduce new terms and conditions to the employee's contract. For example, contractual redundancy pay or enhanced maternity, paternity, parental or adoption leave and pay. So they have their statutory pay, but you'd like to enhance that for them. It might be that you need to change consider changing the contract to reflect changes to an organisation. So, for example, if it's considering moving to a different location or changing people who they may report to. Again, you might need to change it because you're helping an organisation better adapt to changing customer needs. And also you might need to change it for economic reasons. For example, if an organisation is considering a restructure or other changes to stay competitive in a changing marketplace. So while in some circumstances an employment contract can bring benefits to an organisation and its employees, it can also bring significant risks. You should think carefully about the best way to address the issue that you're trying to resolve when you're thinking of changing a contract. So there are risks that we need to consider and to make you aware of. So if we are changing contracts, this can sometimes cause tension within an organisation. If change is not managed well, then risks may include damaging your working relationships with your team. So legal claims, for example, a breach of contract claim or a constructive dismissal claim. So they can be brought by employees with over 2 years of service, because over 2 years of service, they have more employment rights than those employees under 2 years of service. It might also a decrease in commitment and performance from your employees if they do not support the changes, or feel that they have not had the opportunity to inform any decisions.
There's only one groundhog, right? Where is it?
Punxsutawney, Pennsylvania.
Sorry, guys.
Have you ever
Can you
been?
please pop yourself onto mute?
Would you be interested in going?
Joanne, could you pop yourself onto mute, please? There you go. I did. Sorry about that, Jenny. Go ahead.
No problems. So again, thinking about the risks. So if they don't support the change that you're making to that contract, or if they do not have an opportunity that they felt that they've been informed of the decision and the process that you've come to. It can also increase levels of stress and absence within that organisation if we're not managing the process right. We could also get claims of unlawful discrimination. So, for example, if changes are introduced that apply to a group of employees, but put employees with a certain protected characteristic at a disadvantage. So we need to be aware of that. Valued people leaving your organisation because they don't like the change, if they don't support that change that you've made. You then potentially have good reputational damage to an organisational brand, making it difficult to attract any new employees. And a collective action by a group of employees that's not authorised by a trade union. So that could happen as well. So when you are considering changing the employment contracts, it's always good to have that really clear transparency with them and open communication and dialogue with them. Because I think when you explain why something's happening to somebody, they understand it better and then they can make more informed decisions and support you in that process to change that contract. So we've gone through, we've offered them the employment, we've given them the contract, they've worked for us, but then we come to this time where we have to end the contract. So the employee or employer can decide to end or terminate that employment contract. So the employee then may resign, effectively terminating their employment, and the employer could dismiss an employee, which again would terminate that contract of employment. So things to remember with regards to ending of the contract. So we have a resignation from an employee, and they'll be required then to work their notice period. So how long they have to work before they need to end or resign. Your contract, the contract will say how long that notice period is. So we'll have stipulated it in there. And notice periods can change depending on whether that employee is in within their probationary period or out of their probationary period. Having that probationary period, normally after the probationary period has finished, the notice period is longer. Normally within the probationary period, a week to 2 weeks, and then we'd be going to a month, 2 months, 3 months after they finish their probation. It's always good, though, as good practice to respond to a resignation from an employee in writing. That way, then you can, with that employee, you can make sure that that employee has understood that their resignation has been received by yourself. You can confirm their last working day. You can confirm their final pay, including holidays and any deductions. So if they've taken more holiday than they've accrued, for example, that will come out of their final salary. Anything you expect from the employee before they leave. So that could include, a good handover from them before they leave the organisation. So as well as putting these things in writing, it can also help to discuss them with the employee. This can help avoid any misunderstandings or disputes going forward. And then looking at from the employer, when they are dismissing an employee, so we can dismiss the employee for misconduct or gross misconduct, depending on what your policy is, your disciplinary policy is in your handbook. Redundancy, so we can dismiss somebody through redundancy, making sure we followed a consultation process with them. Again, we can dismiss them with notice or pay them in lieu of notice. And ideally, we would always provide a reference to their new employer. So that could be a basic reference, or often called a factual reference. It's a short summary of the employment. So, for example, their job title and the dates that they worked for you. So that way, again, it's keeping that relationship open with that ex-employee going forward. So I think that is the end of my slide.